Hi everyone, my name is Pierre-alain and I'm going to talk to you today about the moral rights in Australia. First of all, I'm going to define the moral right through two different ways, one more simplistic and one more evolved. Then we look at the application with some cases in Australia. We look as well through the presentation and in the end at the argument for and against moral rights. And finally, a conclusion will be given. Simply to explain to you the principle of moral right, I'm going to show you some funny sketches. So you have an author who creates a creation. He then signs a contract, so he gives up some of his right, to have his works published or reproduced. However, no matter what, at any point in time and forever, even if he no longer lives, his heir will do it for him, he keeps the right of the creation. So it means that he keeps the right to decide to have his name on the creation or not. He has the right that his work is not changed. He has the right to withdraw at any point in time from the public his work and keep it for himself. Moral right comes from the French word droit moral, which literally means moral right. A proper definition will be the rights that are inherent by virtue of the act of creation of an author. They represent the respect integral to the act of creativity. After an author signs a contract to exploit his works, the moral rights remain a parallel source of protection. Moral rights are introduced in Australia in 2000 in Part 9 of the Copyright Act. The Copyright Act protects the copyright or the exclusive right to reproduce, to communicate, to perform in public. The copyrights are also called the economic rights and are available for the copyright owner, producer, publisher, distributor, and can be passed on or sold out to someone else. Whereas the moral rights are protected for any person who made an act of creativity in the work, author, director, performer, and are inalienable and indefinite. So the moral rights are defined in three main rights: the right to disclose, the right of attribution, and the right of integrity. So as I explained, the right to disclose is simply the right to decide when and where to release the work, and it includes the right to withdraw at any point in time the work from the public. An author is entitled to have his name protected. That is the right of attribution, so that no one can put another name on his creation or use his names to put on another's creation. An author is entitled to have the integrity of his works protected, so that no one can have his work decreased or subjected to derogatory treatment. No one can distort, mutilate, or alter the material of his work. No one can change the way the artist identifies himself with his works, nor the way that other people perceive the artist through their work. So, if any of these rights have been infringed, the author can sue. It simply has to prove that an act has been done to his work that is prejudicial to his honor and reputation. The author can challenge anyone. A defense of reasonableness exists. He will normally seek for an injunction, damage, apologies, or rectification. So as you can see, moral rights are just an extra layer to the copyright. In Australia, we had only a few cases since 2000. A case of attribution right is the case of Raphael FM Itmeskenas and ACP Publishing Property Limited, where the author wins against a magazine that published the wrong name associated with an image of art. A case of integrity right was the case of Perez and Fernandez in 2012. Fernandez created a false association in a mix between the two artists, association that reflects poorly on Perez according to his international reputation. The court decided that it was prejudicial for Perez's honor and reputation. So the moral rights give the advantage for Australia to comply with the international standard and its treaty obligation. However, some people argue that we didn't really need them, as the law was protecting already some of these rights. There is a civil law tradition or the tort law of defamation that was already protecting reputation. A case, for example, that shows this just point that I just make is Scott Mulsick International and Colossal Record of Australia, where the court look at the base of the work. The standards have changed since, and today the outcome won't be the same. So how far do we really want the moral right to be taken? A case in France called Société and Luc Besson versus Société Publique Conseil and Société Française de Radio-Téléphone was a case that pushed further the boundary of moral right, where the court agreed that having a commercial advert with a similar character of the one that Luc Besson created was an infringement of the integrity and his work in a manner prejudicial for Luc Besson's honor and reputation. So in conclusion, the benefit of moral rights outnumber the negative arguments against them. It expands the spectrum, as every case are not actionable in copyright, but now can be reached in moral right. The question is how far the law is ready to prepare to go.